you would have been incensed that a district court in an adversary system would have come up with a legal theory that neither side had advocated and not giving you a chance to develop it, respond to it, or do anything else. You would have been up here in a heartbeat. You don't have to respond.
Welcome to Price Plow.
What's up, Price Law Nation, supplement industry news followers, and legal scholars, and everyone in between? This is Mike Roberto, founder of Price Plow, with a major supplement industry news alert regarding the Hi-Tech Pharmaceuticals versus United States Federal Government Food and Drug Administration, the DMAA lawsuit. The big one that has, this is for all the marbles. Now, the court case has not been decided. It is early September of 2018. These updates come from mid-August of 2018, where there were some oral arguments heard at the appellate court levels of the 11th Circuit. So that's what we're going to talk about today. Now, before we begin, I do, of course, need to disclaim that I am not a lawyer, but I am heavily versed in this case, having read hundreds, if not 1,000 legal documents from this case, and I do have opinions after reading the facts of the case. I also want to state that while we were sponsored by Hi-Tech Pharmaceuticals in the past, there is currently no business relationship whatsoever between the two companies, and Jared Wheat, nor Hi-Tech Pharmaceuticals, nor anyone else owns Price Plow. And so I want to get that out of the way. However, there may be sponsorship in the future. There was sponsorship in the past, but I am going to talk about some of the facts of the case, but I do have opinions after looking at them. So we're going to talk about the oral arguments that were heard in August of 2018. Now, rewinding a little bit, here's where it all stands. This all started with a 2012, this has been going on for 6 years. In 2012, about $2 million of the DMAA supplements were confiscated from Hi-Tech Pharmaceuticals. They then sued the federal government, stating that there was never any warning about this, that the confiscation was not legal because DMAA is a legal dietary supplement per 1994 DSHEA. And they're stating that this is a constituent of a botanical, and they will prove that it is a constituent of a botanical. And that's been going on since way back, even before that, since the USP Labs days around 2010, if you remember Jack and Oxy Elite Pro. It's been going on for a long time, and we have a lot of new evidence that has been surfaced through this lawsuit over the course of time. And we've blogged about it, and we've seen a lot of crazy stuff happen, and we're going to get into a lot of that. But right now, let's note that this is not about the safety, although some of that stuff comes up in these hearings, and this is not. This is simply about whether or not that confiscation was legal. And the question is, well, is it actually a legal dietary supplement? And now we get to the point where we are arguing about the definition of the word constituent. Is it a constituent of a botanical? Is DMAA a constituent of a botanical? And so what happened was that the district court level, the Honorable Willis B. Hunt in Alabama, decided against Hi-Tech Pharmaceuticals in 2017, where he argued that because there is no history of extraction of DMAA from geraniums, he kind of sided that with the fact that DMAA does seem to be found in geraniums, and it has been nearly a dozen times, as we're going to talk about. Because there is no history of extraction, it is not a legal dietary ingredient. However, that has never been written into the 1994 DSHEA, which is the prevailing law of the land when it comes to the dietary supplement industry, and neither side even argued that. FDA didn't argue that, Hi-Tech didn't argue that, and so that opens the door up for appeal. And Hi-Tech indeed did do that. They appealed this case, and that was around November of 2017. Then the FDA responded, Hi-Tech responded to the response, we blogged about all that, we have PDFs available that will make links in the description, and then things went a little bit quiet. And then in March of 2018, the 11th Circuit Court of Appeals decided to take this case on, but they said, we're going to need to hear oral arguments about this from both sides, and they scheduled that for August of 2018, I believe August 16th. Those oral arguments are actually on public record, and we're going to play a couple clips from them because there's some interesting stuff that happened down. And so those MP3 files are available, and we have links to those in the blog post as well. Everything I'm going to talk about here is in a blog post. And so you can read that along if you don't want to listen or follow or watch here. But basically, we will have links to those MP3 files and to all the documents in the links below. Now, in these Court of Appeals, what happens is that the 11th Circuit covers Florida, Alabama, and Georgia. And so they have about 12 active judges and 8 senior judges, and this is all discussed in the blog post. And three of the active judges are randomly picked into a panel, and then they make a decision. And there's one of 3 ways this really can go. First off is that they can just simply sustain the district court's decision and say, They make a summary judgment. That's it. It's over. Unless maybe Hi-Tech were to appeal all the way to the Supreme Court, which they probably would do, they can sustain the district court's decision and say, this is we agree with this case. It's over and done with. And that would be kind of like the game over case for DMAA and the game over case for Hi-Tech and DMAA in this situation. However, as I'm going to get into, I don't think that's going to happen, and you're going to hear some clips, and you're going to start to understand why I don't think that'll fully happen. I'm not saying Hi-Tech is going to fully win, which is one of the next two potential situations that could happen. I just don't think, in my opinion, that Hi-Tech is going to fully lose like that. I don't think this is going to be sustained. So the other two things that can happen is that the decision can be reversed and rendered, which means that the losing party is now the winning party, which means Hi-Tech, it's reversed. Hi-Tech is now the winning party, and it's rendered, and there's no more further things to be heard. The judgment is final, and the judges just keep it here. At that case, maybe the FDA could appeal to the Supreme Court. I'm not really totally sure about that. There's a lot of legal jargon that happens here, but to reverse and render is to make a final decision at this level. And then at that point, I believe DMAA would be back on the market. And basically the next day after that, you're going to see PJ Brown and Jared Wheat making a video, and they're going to be manufacturing DMAA pretty much the next day as far as I am aware. And the other way it could go is to reverse and remand. And in that case, once again, the decision is reversed, and Hi-Tech Pharmaceuticals is given like a win, at least a temporary win. But the Circuit Court of Appeals could then send it down back to the district court level to either be retried and completely retried, potentially even as a jury trial, or they could send it back down to the district court level to retry it with some specific instructions, such as let's maybe dig deeper into this history of extraction because nobody ever argued it. There's never a chance for anyone to develop that. So those are the three things that could potentially happen. Now that we've kind of seen where it stands, let's get into the oral arguments themselves. And again, the MP3 is available publicly. We'll have it backed up and archived on our own site and all that. And one thing to note, though, is that the decision has not yet been made. Sometimes the decisions come fast. Sometimes it takes like 9 to 12 months from hearing these oral arguments until hearing the actual final decision. And until then, Jared Wheat has agreed not to manufacture or sell DMAA, so it is currently off the market and is not being sold as a supplement, at least not by Hi-Tech. So this all hinges on Hi-Tech. But in this case, because we're talking about a constituent of a botanical, there's actually a lot more at stake here for the dietary supplement ingredient. And so basically, this isn't just about DMAA. This is about any of those ingredients where it's not necessarily ever been historically extracted, but hey, we found it in a certain fruit, for instance, and now that makes it a constituent of botanical. That's what we're going to argue about. And we are literally going to get into the dictionary definitions of the word constituent here. That's how vague 1994 DSHEA is, and it's, it really is up to the judges to judge and to interpret the law, especially when the laws written per Congress were kind of vague. And so that's just kind of the hand that's been dealt. And so here we go. Now the two sides were argued by two gentlemen. This is a 36-minute long audio file where the judges, there's no crosstalk or none of that TV nonsense or nothing. This is basically the judges ask and discuss questions with Hi-Tech first, because they're the appellate. Then they, at the 12-minute mark or so, they move over to the FDA, and then they ask some questions back to Hi-Tech. Hi-Tech was represented by a lawyer named John Neiman from the Maynard Cooper and Gale law firm. Interestingly, he is a very well celebrated. You're going to see, I'm going to say he did a fantastic job in this case. He has experience in these situations, and you're going to understand why when you hear some of his clips. He does a good job, and he has some sticking points, and he has some memorable things that he says, and he does a great job. Meanwhile, the FDA's attorney is a man named Daniel Aguilar, who comes from the U.S. Department of Justice's Civil Division. So they're bringing out some big dogs for this. You have two incredibly professional, great lawyers, and they conducted themselves both admirably. Now, in terms of the judges, you have an interesting slew of judges, and one of the judges kind of tips his hand, and we're gonna play some clips from what he said here. This is all public records. We're going to splice in some clips, but one of the judges does show some annoyance with the district court's decision here, and so it makes me believe that this guy's not necessarily going to side fully against Hi-Tech Pharmaceuticals. So you have a panel of 3 judges asking these gentlemen questions. So being the appellate, Hi-Tech Pharmaceuticals, John Neiman gets to go first. And he starts by making 3 main arguments. First, he says that the district court misinterpreted the definitions of the word constituent and botanical as written by 1994 DSHEA. Second, he argues that when properly interpreted, that Hi-Tech Pharmaceuticals will prevail in this case. And third, he says from a health perspective, there's nothing to be concerned about, but it's very important to note that this is not the venue for that type of argument anyway. He says that the FDA basically flipped the script. The FDA, the burden of proving an ingredient to be unsafe is always on the FDA. That is how the law is written. That is the FDA's own rulemaking process. By performing this confiscation and forcing Hi-Tech Pharmaceuticals to sue them in order to get their stuff back and to get their ability to sell DMAA back, the FDA essentially flipped the script here, and that is against their own rulemaking process. And so while Hi-Tech Pharmaceuticals has shown toxicology reports, and we can get into that a little bit, this isn't even the venue to talk about that. Until the FDA is able to prove that this is an unsafe ingredient, which they haven't been able to do, until they're able to do that in a different venue using their own rulemaking process, such as the way that they did it with ephedrine alkaloids in ephedra, this is not the venue for that, and this should still be a legal dietary supplement. But Hi-Tech Pharmaceuticals is happy, and they have already provided a lot of evidence showing that there is safety. In fact, the Department of Defense's own report on the users who were mostly using Jack back in 2012, I believe, showed that DMAA users were less likely to have an injury than non-DMAA users. And so there's an uphill battle, and because of that, we think that that's why the FDA, or I personally believe that's why the FDA did flip the script here. And because of that, what Neiman is saying is that that shows prejudice, which means that this is ripe for appeal. And that's why these judges did seem to take up this case, because there are definitely some issues that are appealable, and here we are. So the argument then gets into, what does the word constituent mean? And at this point, the judges then they literally are talking about dictionary definitions, because Congress, when they wrote 1994 DSHEA, never defined the word constituent. And they also didn't define the word botanical. And so we're talking about a constituent of a botanical, yet these words are undefined. And we've gotten into the nitty-gritty so far that we are literally busting out Webster's Dictionary. And that's not to like talk bad about the judges, but it's just to show that that's how vague this law is. To Hi-Tech Pharmaceuticals and to most laymen, and I don't want to misquote that, a constituent is, quote, part of something else, and the botanical means plant. And so by that definition, Neiman argues that DMAA has time and time again been proven to be a constituent of a botanical. Even the FDA's own research cited showed that they found DMAA, and they kind of covered it up, but that's a whole other story that we can get into at another time. But the FDA's own burden was not satisfied. Hi-Tech basically makes the argument that when Congress was writing DSHEA, they were trying to make the supplement industry open to a whole wealth, a whole plethora of vitamins and minerals and everything, and they kept it quite open-ended for that reason, is that they didn't want to stifle it, and that's how it was written. So there's multiple definitions of the word constituent that are floated around during these hearings, but essentially Neiman argues that because they kept this such an open-ended type of law, there's different ways of contesting different definitions of words, and there's like legal books that cover some of this stuff. And so he's saying because of this this open-ended law, you go with the more broad of the two definitions. Now Neiman then makes a pretty cool analogy, and this is where he's good. He's got a lot of these like sticking points that in an otherwise monotonous day the judges will probably remember. And so he makes an argument basically, and I'm just going to play the clip.
So if the court were to ask me to go fetch as quickly as possible an ingredient of a cake, I would try within the 3 minutes and 45 seconds I had left to go sprint to the lawyer's lounge and bring back a bag of sugar from the coffee table over there. And I think I would have complied with the court's request to bring an ingredient of a cake with me, even though that sugar had never actually been extracted from the cake itself. As long as everybody acknowledges that sugar is a part of cakes, and the fact that there's no history of people extracting sugar from cakes, or that the sugar I brought you had never actually been in a cake, would not change the reality that sugar was part of a cake.
You can kind of get where this guy's going, and he kind of makes some good arguments, both from the scientific standpoint, but then also to the layman standpoint, to the judge who, and these judges do seem to understand this a lot, but he really like puts it into perspective really well. So I thought he did a really good job with that. After that, we get into some of the stuff that I am very passionate about, because this court case showed a lot of stuff that we had literally been flat out lied to by not only the government, but by a lot of the more mainstream press and some of the even industry press and some of the researchers. Basically, Neiman makes the argument that the FDA set out to prove that DMAA was not a constituent of a botanical, was never found in these flowers. And in fact, and so the USP labs back in the day cited 3 studies, the Ping, Lee, and Fleming studies, and they funded 2 of those studies, but they did show that DMAA was found. Well, the FDA wanted to make conclusive arguments that it was not found, so they funded some studies as well. You and I, United States taxpayers, funded one of those studies to the tune of $2.3 million. And it turns out that those studies funded by the FDA themselves did find DMAA, but did not report it. It was a constituent or a part of a botanical or a plant, i.e. Geranium pelargonium. And so what Neiman is anyway getting into is that he states that the FDA didn't satisfy their own burden. Once again, the burden was on the FDA to show that it was not, and the data that they have and that we paid for actually showed that it did occur. And nearly a dozen times DMAA has been found in geraniums. So long story short with that, Neiman basically just asks, hey, judges, look at the evidence at hand. It's pretty clear what happened here. This stuff is found in nature, constituent of a botanical. And so then the judges kind of ask, well, what about safety? And should that go into account here? And Neiman says, hey, listen, Hi-Tech Pharmaceuticals is happy to talk about safety, but this is not the venue for that. The FDA has their own rulemaking procedures, and they didn't follow it. Like we said in the beginning, in the intro, FDA flipped the script, and they didn't follow their own procedures. So when this ingredient comes back onto the market, Hi-Tech Pharmaceuticals is happy to show safety. However, this is not that case. This is about a confiscation, talking about whether or not it is an ingredient yet. And it was discussed in the lawsuit at the district court level, although that isn't the biggest part of this case. It really comes down to the constituent of botanical and the historical extraction decision made by the district court judge that nobody argued, once again. So long story short, the FDA needs to follow their own rules, and they need to look at their own data, both of which they didn't do, and that's why we're here for appeal, and that's why Hi-Tech Pharmaceuticals is asking for a summary judgment, reverse and render this decision. DMAA is a legal supplement per 1994 DSHEA by interpreting the word constituent of a botanical as a part of a plant, which it most absolutely definitely is. Okay, so after that, it's now at about the 12-minute mark in this thing. You can see these question and answers go fast. There's no rambling like we do here on YouTube. This is fast. Now it's the FDA's turn. And so the FDA comes in, and so Daniel Aguilar of the United States Department of Justice comes in for the FDA and states his main 2 points. He states that the United States District Court did make the right decision based upon two questions that he feels were properly answered at the district court level. First off, is DMAA a constituent of botanical, or is it a food additive? And they believe they made the case that it is actually a food additive. And second, if it is a food additive, is it unsafe, or is it generally recognized as safe or GRAS per a scientific panel of experts? And they believe that it is not. And so they make the argument that this is not a dietary ingredient. It's instead an unsafe food additive. So they believe that the district court made the decision properly, and that's why they also want to go summary judgment. They don't want to go back to court down to the district court level either, and they want this decision to be maintained. Now, what's interesting here is that oftentimes, and this is going on throughout the whole case, there's always a lot, like Hi-Tech's lawyers always write in pretty clear English that a layman can read, and the FDA's never do. And this kind of happens again in this video where you get a lot of legal jargon thrown about, and it's all about procedure. FDA is constantly trying to win on technicalities. When can you come to summary judgment? When can you not? All this stuff that honestly, as a non-lawyer, I can't fully explain it all. But it seems like Hi-Tech, when it comes to the statements of facts and the facts of the case, Hi-Tech is in the right. But when it comes to the technicalities, that's where the FDA tries to do a lot of legal maneuvering. They are always playing the technicality card, and you get a little bit at the 13-minute mark, and so it's just like been consistent with this case. But really, the crux of the appeal is at the 14:20 mark. This is where the judge tips his hand a bit, because he states, he asked the FDA to confirm, like, was this decision at the district court level made based upon something that nobody had ever argued? And the FDA agrees that it had. And at this point, the judge gets a little bit fired. We're going to have to play that clip. But he's basically like, let's flip the script. If that had happened to you, you would have been up here at the appeals court in a heartbeat.
However you view it, the district court adopted an interpretation that you had not proposed. Am I right so far?
That's correct.
Okay. And that interpretation was not purely legal. It was based on facts in the record as well in terms of whether to grant summary judgment or not, right? Because the district court said there had to be a history of extraction in usable quantities, right?
Yes.
You had not proposed that standard.
Correct. That our standard was that it didn't exist at all.
Correct. So you had not proposed that standard. That is evidentiary. In order to show a history of anything, you need to do discovery. You have to show whether something happened in the past or didn't happen in the past.
But going to this point,
you can't ask a party to show prejudice due to lack of discovery without giving them discovery.
But they had discovery on this, Your Honor.
No, they did not. You did not tee up the issue. The government has the burden in a forfeiture proceeding, and you have to assert a legal theory on which the government can forfeit goods. Is that correct?
Yes.
And if you tee up a certain theory, if you say these goods are forfeitable for reason X, that's the only reason that the claimant has to fight. It doesn't have to fight other things in the either that it doesn't know about.
But here's the thing, Your Honor.
If the district, let me flip this question for you, make it a little more difficult for you. If the district court had come up with a legal theory, statutory interpretation that Hi-Tech had not advanced and had said, I'm coming up with theory number 3 and granted summary judgment against you, would you have appealed?
I mean, obviously that's a deliberative process set up to the Solicitor General, but I'll assume that we would appeal that.
I mean it in a practical sense. I'm not asking you to give me any state secrets.
Sure. I'm just saying here that we would have appealed,
you would have been
we would have also agreed
incensed.
that we would have had to show
you would have been incensed that a district court in an adversary system would have come up with a legal theory that neither side had advocated and not giving you a chance to develop it, respond to it, or do anything else. You would have been up here in a heartbeat. You don't have to respond.
Hi-Tech didn't fully understand that they needed to go and look at the history of extraction to see what, there's a patent up in Canada, and it is still valid, that Iovate was able to get out of a different form of geranium robertianum, 3% extract. But they never had a chance to fully look into that in discovery because no one warned them about that, and no one ever made that argument. And so there was never a reason, really, to argue that. And so the judge is kind of tipping his hand. He's like, you would have been here too. This is obviously a kind of a common sense time to appeal. And so I believe that judge is Judge Adalberto Jordan. He definitely shows some skepticism with the district court's decision here. And because of this, at this moment, I think that this gentleman, at least, is not going to fully side against Hi-Tech Pharmaceuticals. Furthermore, you have one of the other judges who has already once decided against the United States government. So, for a lot of the people out there who think that the court system is an apparatus of the United States government, and Hi-Tech is fighting the United States government. So, the deck does seem stacked against them. It turns out that these judges, they seem to be like they really want to get into the facts of these cases, and they are willing to go against the United States government, and they even show some annoyance with this. So I find that to be pretty interesting. Now, once again, with the FDA's side of questioning, we get into what is the definition of the word constituent. So there's different ways of interpreting these words, and the FDA states that, hey, when you have a contested word, you look at the definitions of the words around them, and you see what context they're in. And he cites some stuff by the late, great Antonin Scalia, and talking about, we need to look at the context of the other words. The other words in the DSHEA provisions are metabolite, you have constituent, extract, combination, and concentrate. And he's saying these are all physical methods of derivation. However, constituent, because of that, constituent should be a physical thing as well. And there's never been true physical extraction of DMAA that has been sold into the market. And for that reason, they do agree with the district court level. The judges show a little bit of skepticism with that because they're not so sure the constituent is still in the same vein as those other words. And so once again, we're just arguing about how we define words. We're not even arguing about the definition. Now we're arguing about how we make definitions of the definition. And so that's how deep down the wormhole you can go with with these situations. And so this is where, And so the judge asked a very good question now. And I might just play the clip, but basically he says, okay, let's say I have a tree and it has a high amount, like 50% of ABC magic dust. And then some company comes out, but that ABC magic dust has never been extracted from that tree. But some company comes out and makes ABC magic dust in a lab and then sells that on the dietary supplement market. He's like, are you saying, the judge is asking FDA, are you saying that that is not a legal dietary supplement? And Aguilar answers, yes, I agree that that would not be a legal dietary supplement because it has never been extracted, even though it's capable. So the judge asks, like, okay, so what if someone then did extract it and put it onto the market? Then is it legal? And then Aguilar says yes. And I believe, personally, I believe this was his fatal mistake here, at least in terms of winning, because he's saying that if someone were to extract DMAA, perhaps from geranium robertianum, and then put it onto the market, then it becomes a legal dietary supplement. And because of this, he's opening the door for Hi-Tech at least to have more arguments at the district court level. And so I think that that was a fatal mistake by the FDA's lawyer, but that's just me personally, coming from a non-lawyer layman. I think he opened a door that cannot be closed unless it is proven that the iovate patent up in Canada is bunk. And so that's still a possibility as well. And so lots of things happening. But at that point, I believe that when he made that argument about the ABC magic dust, it needs to be extracted. And then once it's extracted, it's legal. Then Hi-Tech has the chance to further develop this evidence. And I don't think Hi-Tech, because of that argument. For Hi-Tech, at best, in this case, they're going to get it reversed and rendered. And I think, honestly, at worst, I think it's going to kick back down to the district court level. I just don't see Hi-Tech completely losing this, but crazier things have happened, especially in this case, especially when people just want to ignore the complete cover-up hatchet job that was done by some of these researchers, etc. And so what's interesting is the FDA has also asked for summary judgment. They want this to be over and done with. They have basically put all their cards out there, and they also have not asked to go back for more arguments, and both sides are at that point. We'll see if the judges actually listen to that, or if they do kick it back down to the district court level. But both sides have asked, like, hey, we've put down our cards on the line, and FDA's made their case. Hi-Tech's made theirs. They've showed their evidence. FDA believes it is an unsafe food additive. Nobody wants to go back to the district court level, but there are some questions that could be answered at that level. But then, as they would say, it would become more of a battle of the experts type of situation. After that, they go back to the Hi-Tech, and Hi-Tech basically says, hey, we didn't further develop the information regarding the iovate's patent. They don't mention iovate, but iovate is the Canadian patent owner up there, and who has the patent on the geranium DMAA extraction. Is that we didn't develop that because we didn't think we need to. Right now, at that point, the burden was to show that DMAA was a constituent of botanical, and the FDA's own studies that the FDA cites are the ones that show that it is a constituent of botanical. So, you know, and he didn't mention this argument, but like I'm saying, why would they go and have to deal with a competitor, which is what iovate really is? Why would they have to go deal with a competitor, pay all their experts, get all their time, pay for that patent and all that stuff, when they already satisfied destroying the FDA's part of that case? So as we've seen in this case, the goalposts have continually moved on USP Labs and on Hi-Tech Pharmaceuticals. At first, USP Labs needed to prove that it was a constituent of botanical. They did that, but it wasn't good enough. Then FDA came out with some studies that were flawed, I would say fraudulent personally, and they did not tell the full truth. And once those were revealed by Hi-Tech Pharmaceuticals at the district court level, the goalposts once again moved. Now we have to show history of extraction. It's like that's not in the law anywhere. At some point, these goalposts are just either going to keep moving and it's a big sham and Hi-Tech is going to lose, or someone's going to put a stop to this. But the fact of the matter is, the absolute fact of the matter is that DMAA, even if in minute doses, minute quantities, DMAA is found in geraniums. It has been found nearly a dozen times. People who are looking and people who weren't looking found it. And so for that reason, depending on how you define the word constituent of a botanical, the strict definition of constituent of a botanical or a plant, DMAA is legally viable, at least, per 1994 DSHEA. And that is Hi-Tech's argument. And they've shown that. However, the goalposts continue moving, so we really don't know what's going to happen. And it might be a little bit of time for us to find that decision, because sometimes these take 9 to 12 months. And until then, Hi-Tech Pharmaceuticals is selling their DMHA-based supplements. And the market's most of the DMAA is gone from the market. Thanks for listening. Hopefully that does a good job covering things up to September of 2018. You can subscribe to our channel. Please leave comments below and subscribe to the channel and sign up for our alerts, our news alerts on price.com/Hi-Tech Pharmaceuticals. And so you know that the second this decision is made, we will be updating this, making a video, putting out a blog post and all that. We have links in the description. My name is Mike Roberto. I'm the founder of PricePlow. I have seen the lies, I've seen the cover-ups, and I've seen the data. DMAA is found in geraniums. Maybe not in huge doses, but it is there. It is a constituent by the very definition of the constituent, a part of a greater whole. So I will not argue that 1994 DSHEA is a very vague law, but if we want to strictly interpret it, which is what the judges should do, as constitutionalist judges, it is a constituent of a botanical. Mike Roberto signing out. Sign up for the alerts because we have more coming. Thank you very much.
Welcome to PricePlow.